Can you be a secured creditor with a structured settlement? The answer is yes. There's no need for you to be a general creditor if a secured creditor is available. Secured creditor has been available for structured settlements since 1988. It's important if you are entering into a settlement agreement or your client is entering into a settlement agreement to make sure that you're using a document known as the Qualified Assignment Release and Pledge Agreement. Qualified assignment is an agreement, a legal agreement that's used to transfer or substitute the obligation of the defendant or the defendant's insurer with an assignment company. The assignment company is the company that actually buys and owns the annuity. And when there's secured creditor, as part of the qualified assignment process, there's a pledge of the annuity to the plaintiff, or actually to the payee, to secure a lien and security interest in that asset. The specific terms of the secured creditor status or the security interest are set forth in the qualified assignment document. So it's very important to, number one, make sure you're using a qualified assignment release and pledge agreement if that's what you're interested in, and then to read it carefully so that you understand the security interest that you're getting into. You should always consult with an attorney as well to make sure if there are other forms that you need to file under the Uniform Commercial Code. If that's something that's necessary, you should be consulting an attorney in that regard. But at least you should be using the Qualified Assignment Release and Pledge Agreement. All but 2 of the life insurers that issue structured settlement annuities offer secured creditor or security interests in the annuity contracts as part of their qualified assignments. The 2 that do not are Liberty Life and New York Life. And if you're doing a non-qualified assignment, non-qualified assignments would be a case where there are taxable damages, or the portion of the case that represents taxable damages, whether it be interest, an employment case, or any other type of taxable damages. Those type of cases cannot have secured creditor status. Only the damages that, or structured settlements that represent damages that represent personal physical injury or workers' compensation qualify for this type of treatment. So the bottom line is, if you have an interest in having a security interest in the annuity contract, you must make sure that this is documented through the use of a qualified assignment release and pledge agreement. The 2 other types of qualified assignment documents, one is called a qualified assignment and the other is called a qualified assignment and release. Those 2 documents do not afford you a security interest. So qualified assignment release and pledge agreement. The Qualified Assignment Release and Pledge Agreement is offered by all but 2 of the structured annuity issuing life insurance companies in the United States. It's possible that if you had a structured settlement issued between 1988, when the ability to be a secured creditor came into play, up to the present, it's possible that you may not have secured creditor status because the company did not offer this. Not everybody offered it right away when there was a change in the law. But the majority of companies do today, and you should strongly consider that as part of your settlement planning if you're concluding your case with a structured settlement. Thank you. This is John Derer. Have a great day.